Yeah.
And do you understand that this sentence should run concurrently with the sentence that you are already serving for 19 SC defect?
Yeah, I will bring it to you in its entirety. I am waiting for the 3 minutes to go by, and then I'll put it up on the screen. Let's make a deal. No, I'm talking to There you go.
All right, Ms. Ryan. Yeah, come up to the podium and then Sergeant Ingram, can you swear Mr. Ryan in?
Yes, sir. Rodalius Ryan, Rodalius Ryan, Ryan.
And Mr. Ryan, are you the same person referred to as Rodalius Ryan on indictment number 22 SC 183572?
Yes, ma'am.
Are you at this time under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you?
Currently 20 years old.
And how far did you go in school?
12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged in this indictment with count one, conspiracy to violate the Racketeer Influence and Corrupt Organization Act, which carries a sentence of 5 to 20 years?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had an opportunity to go over this plea of guilty and waiver of rights form with your attorney?
Yes, ma'am.
And have you and your attorney both reviewed it and you signed this document?
Yes, ma'am. That's my signature.
That's your signature?
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Leah Abbasi, about all of the facts and circumstances known to you regarding charges in this indictment?
Yes, ma'am.
Have you been able to speak with her about any potential defenses?
Yes, ma'am.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with her counsel and representation?
Yes, ma'am.
You also had another attorney, Ms. Angela D. Williams. Are you satisfied with her counsel and representation?
Yes, ma'am.
Do you waive formal reading of the indictment?
Yes, ma'am.
And do you waive any defects, if any, with respect to the indictment?
No, ma'am. Could you repeat that for me?
Sure. Do you waive any and all defects in the indictment? If
Yes.
And have you been arrested on these charges, specifically count one, the conspiracy to violate the Racketeer Influence and Corrupt Organizations Act?
He was already in custody, so he was not taken into custody for these charges. However, he was booked for the charges in the Fulton County Jail.
And he was served with the arrest warrant on this.
Yes.
Has Ms. Abbasi advised you of the minimum and maximum sentence for the charge that you are pleading to?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve, commuted to the time you have served in this case? Do you understand that?
Yes, ma'am.
And do you understand that this sentence should run concurrently with the sentence that you are already serving for 19 SC 168236? Do you understand that?
Yes, ma'am.
Do you understand that the court does not have to accept this recommendation?
Yes, ma'am.
And the court can sentence you to the maximum on this charge.
I understand.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you are not
I'm
in the
sorry,
United
one
States?
moment. Please repeat the question. Do you
The one on
understand that the
enhancing
conviction?
sentence, that one, the one on enhancing sentence?
Yes, I just needed to explain a bit more what that means.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, and transport a firearm, or the ability to obtain employment. Do you understand that?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? And after I say each right, I'll ask you to respond, okay? The right to trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assist of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
and the right to appeal if convicted of these charges at the trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
With respect to indictment 22 SC 183572, how do you plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes, ma'am.
Do you also understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
And do you also understand that you have until the end of this term of court to file a motion seeking to withdraw your guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed and continue with trial, Your Honor, evidence has shown and will will further show that Mr. Ryan conspired with others to participate in the Young Slime Life gang through a pattern of racketeering activity, and multiple defendants and unindicted co-conspirators have committed overt acts to further this conspiracy, including sales, aggravated assault, and murder, also including social media posts asserting the violent nature and dominance of Young Slime Life, aka YSL. Your Honor, the court has been present for evidence regarding the February 23rd, 2019 homicide of Mr. Jamari Holmes, in which Mr. Ryan and YSL co-conspirator, Damon Blaylock, lured both Jamari Holmes, Bernard Mitchell, and Rodney Hooten to an apartment at 50 Mount Zion Road, which is in the Cleveland Avenue area. The evidence came out that during the course of that incident, that Mr. Ryan, along with Mr. Blaylock, emerged from the apartment complex, shooting at the vehicle which Mr. Holmes, Mr. Hooten, and Mr. Mitchell were in, shooting Mr. Holmes in the head. After this incident, a few hours later, Mr. Ryan is seen posting on social media, on a public social media post, saying bet YSL makes the news. Right, there has been other social media posts in which Mr. Ryan has promoted or enhanced the reputation of YSL. Your Honor, the state intended to show further evidence that once Mr. Ryan was convicted of the homicide of Mr. Holmes while in prison, he continued to enhance the reputation, power, and territory of YSL. Specifically, when YSL co-conspirator and co-defendant Christian Eppinger was given a bond for shooting at an Atlanta police officer, Mr. Ryan, while on a contraband phone in prison, posted on his social media accounts, he flashed a YSL sign and stated, "We're coming to get you. YSL shit, free my N-word brisk, F the DA, the gangway, we catching bonds on this shit." Your Honor, this is the evidence that the state would have intended to show if we would continue the trial. Given the current status, Your Honor, we've made an offer to Mr. Ryan for this commuted to time served offers from our concurrent with his current conviction, Your Honor. And I can approach with the documentation.
You may. And I wanted to just add one thing to the information about the different methods you have to file things after this plea. And that is that Misty Williams and Miss Abbasi will represent you until either the end of this term of court or 30 days, whichever's later. And so they would be the ones to talk to about filing those things, unless either of them is permitted to withdraw before that time. They would be the ones to file those for you, okay?
No.
All right, Miss Abbasi, is there anything that the defense wants to add to the record?
Yes, Your Honor. Your Honor, I have had the honor really of representing Mr. Ryan along with Misty Williams, who I'm quite disappointed she could not be here today for an important day. This trial has been exhausting for everybody, and that certainly includes Mr. Ryan, who has been going through the court system since he was 15 years old. We categorically and adamantly deny that YSL is the criminal, dangerous street gang, which it's been made out to be through this trial. We're actually quite happy with the record, which was established during the presentation of the state's evidence of the alleged murder of Mr. Jamari Holmes. This plea today, Mr. Ryan is making a decision which is going to be the best for his future, what future he has, because he's already serving a life sentence. Were he to be convicted and sentenced to additional time, he would remain in custody. As I stated, we think the record established will strongly support his appeal, and hopefully, when his conviction is overturned, we don't want him sitting in prison for something else. Certainly not for actions he took when he was younger, and actions he took which are largely a product of how he grew up. As I stated, Your Honor, Mr. Ryan was 15 years old at the time of the Jamari Holmes murder. You've seen through the text messages, he was out at all different hours, doing all different things, which I don't think anyone would want their 15-year-old to be out doing. And so that is where he was. And so he did adopt the people who were around him, the people who could support him, the people in his neighborhood who grouped themselves, calling themselves YSL. Mr. Ryan at no point was trying to advance a criminal street gang and their interests. He was trying to protect himself, being a young person, largely on his own, and this is where he's ended up. I would like to say that there's been some sort of rehabilitative function here since he was sentenced to prison. It doesn't appear that that has happened. As you've heard, some of his additional cases are within the prison system. It would be wonderful if some of the money spent on a case like this could possibly be invested in the future of people like Mr. Ryan, who go into custody at such a young age and who really then are not given the resources to make the changes that they really would like to make to have a productive future. With all of that said, I think Mr. Ryan has grown up a lot during this trial. He doesn't want to sit through this anymore. He doesn't want to ever be back in a courtroom ever again, Your Honor. He's heard about all sorts of incidents, which the 2015 crimes, he was 11 years old. Mr. Ryan's most sincere wish is to move on with his life, to put this behind him. And we thank the court for the opportunity to resolve the case in this way and not drag it out any further than it has been. He just would like to thank the court, Judge.
All right, thank you. And Mr. Ryan, I just want to make sure that you understand that this is ultimately, the decision is yours to make, not your attorneys. And I appreciate that both Ms. Abbasi and Misty Williams have been available in giving you legal advice and guidance, but it's ultimately your decision. Do you understand that?
Yes, ma'am.
All right. And do you, in fact, want to plead guilty?
Yes, ma'am.
All right. And you've had enough time to think about it and to discuss it with your attorneys?
Yes, ma'am.
All right. And Ms. Abbasi, have you and or Mr. Williams talked to Mr. Ryan about the benefits and drawbacks of all of his different options?
Yes, Your Honor.
All right. All right. I find that there is a factual basis for the guilty plea to count one, the conspiracy to violate the RICO Act. Whatever the difference of opinion may be with regard to what YSL is or isn't, and what Mr. Ryan may or may not have intended, there is a factual basis that exists from the record as it already is in this case to support the necessary elements of the conspiracy to violate the RICO Act. And I have heard many of the alleged overt acts and the conspiracy evidence to advance the enterprise through a pattern of racketeering activity and to control personal property and money. And I find that the factual basis for that exists. And I am going to accept Mr. Ryan's guilty plea. I find it to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences of this plea. And I'm going to sentence in accord with the recommendation that both of the state and the defense have worked hard to negotiate here, which is a sentence of 10 years commuted to time served and to be run concurrently with the sentence that Mr. Ryan is currently serving. And certainly within the court's consideration is the knowledge that Mr. Ryan is at this time serving a life sentence for the murder of Mr. Holmes. And while I understand that that is on appeal right now, you know, those are the facts as they exist right now. So that is the sentence of this court. Mr. Ryan at 20 years old, you have most of your life ahead of you, and I don't know what it is going to hold with regard to your appeal or anything after that. But whether it is more years in custody or whether at some point in time you see the light of day to the outside world again, which is very likely considering your age, as long as you behave yourself while you're incarcerated and do not continue to either commit crimes in prison or violate any of the prison rules. If you can be on the straight and narrow, then somebody your age, after serving some amount of time, is probably going to be considered favorably for parole. And you just have to keep that in mind, that you need to be looking out for sort of the long run and not playing the short game, but playing the long game so that you have a future in front of you still. So that is your sentence, and I wish you luck, and I wish that with further maturity, much like Ms. Abbasi has said that you have already exhibited throughout the course of this trial, that you are able to make better decisions and steer your life in a better direction. Thank you.
Thank you.
Mr. Matthews, are y'all ready? All right. You may. Yes, and I'm going to go ahead and, where's Mr. Foster? Give you these documents. And then this document, give Mr. Okay. All right, so we already have the signed copy of the indictment. Mr. Huey and Mr. Ryan have both signed, so I have that already. Yes. Okay. All right, and Sergeant, if you can swear in Mr. Huey.
Yes. My name is Marquavius Huey.
Your Honor, we have just received the redacted document here, so if I can have an opportunity just to execute the document.
Absolutely.
Thank you.
Right.
And Mr. Matthews, just so that the record is clear, I know that y'all are just now signing I guess it's still a, 5-page document? This is not the first time you're seeing the most of what's in that document, correct?
Absolutely
This is,
not.
right.
We've seen
So
this.
there were a couple of items removed from the sentencing acknowledgments at your request. Is that right?
That is correct, Your
Okay.
Honor.
And otherwise, other than that section 4, everything has essentially stayed the same with regard to the rest of the document. Is that correct?
That is also correct.
All right. And you and Mr. Matthews and Mr. Huey were aware of the changes that were getting made?
Yes.
All
Your
right.
Honor.
Do y'all need any additional time to look over the refreshed document?
We do not, Your
All
Honor.
right.
I've reviewed it, and we are ready to
All
proceed.
right. Sounds good.
Okay, I have it.
No, that's all right. It's essentially the same. Okay, thank you. So you've got the a waiver of rights and this separate kind of list of the charges and the sentences. Okay. And the indictment is with Ms. Rosser. I'm ready whenever.
Mr. Hill, you please raise your right hand. Do you solemnly swear that the evidence you shall give in the matter now pending before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hands down.
I think he already got sworn, so you're double sworn at this point.
Please state your true and correct legal name.
Marquavius Huey, Marquavius Huey.
And are you the same Marquavius Huey on indictment 22 SC 183572?
Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you?
28.
And how far did you go in school?
12th grade high school diploma.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you were in this indictment charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carried a sentence of 5 to 20 years?
Yes.
Count 3, you were initially charged with armed robbery, which carried a sentence of 10 to 20 years or life.
Yes.
You were charged with count 4 and 5 of this indictment, aggravated assault with a deadly weapon, which each carry a sentence of 1 to 20 years.
Yes.
You were charged with count 6 and count 7 in this indictment, which you charged of possession of a firearm during the commission of a felony,
Yes.
and that carried a sentence of 5 years to serve consecutive to any other count in the indictment.
Yes.
You were also charged with armed robbery in counts 14 and 15.
Yes.
Also charged with aggravated assault with a deadly weapon, counts 16 and 17.
Yes.
You were charged with hijacking a motor vehicle in the first degree.
Yes.
You were initially charged with possession of a firearm during the commission of a felony,
Yes.
counts 19 and 20. You were charged with 4 counts of participation in criminal street gang activity, which were counts 21.
Y'all, I'm sorry. I'm starting back over a little bit. I wanted to get the better volume for you, but so I'm gonna pick it back up. We're at the beginning of Quay, right? So we won't miss anything. But I just want to let y'all know what I said. These are consolation, consideration, and concession pleas. Okay. So, but I'll explain that. Let me go back to the program and I'll explain that once they're done. But let's make a deal.
We do not.
All right.
I've reviewed it, and we are ready to
All
proceed.
right. Sounds good.
Okay, I have it.
No, that's all right. It's essentially the same. Okay, thank you. So you've got the a waiver of rights and this separate kind of list of the charges and the sentences. Okay.
Yes, Your Honor.
And the indictment is with Ms. Rosser. I'm ready whenever.
Mr. Hill, you please raise your right hand. Do you solemnly swear that the evidence you shall give in the matter now pending before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hands down.
I think he already got sworn, so you're double sworn at this point.
Please state your true and correct legal name.
Marquavius Huey, Marquavius Huey.
And are you the same Marquavius Huey on indictment 22 SC 183572?
Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you?
28.
And how far did you go in school?
12th grade high school diploma.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you were in this indictment charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carried a sentence of 5 to 20 years?
Yes.
Count 3, you were initially charged with armed robbery, which carried a sentence of 10 to 20 years or life.
Yes.
You were charged with count 4 and 5 of this indictment, aggravated assault with a deadly weapon, which each carry a sentence of 1 to 20 years.
Yes.
You were charged with count 6 and count 7 in this indictment, which you charged on possession of a firearm during the commission of a felony,
Yes.
and that carries a sentence of 5 years to serve consecutive to any other count in the indictment.
Yes.
You were also charged with armed robbery in counts 14 and 15.
Yes.
Also charged with aggravated assault with a deadly weapon for count 16 or 17.
Yes.
You were charged with hijacking a motor vehicle in the first degree.
Yes.
You were initially charged with possession of a firearm during the commission of a felony,
Yes.
counts 19 and 20. You were charged with 4 counts of participation in criminal street gang activity, which were counts 21, 22, 23, and 46.
Yes.
And you were charged with possession of a weapon by an incarcerated individual, which was count 44, and possession of a telecommunication device by an incarcerated individual, which was count 45. You understand that those were your initial charge in this indictment?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had an opportunity to go over this waiver of rights form with your attorneys?
Yes, ma'am.
And is this your signature on this document on page 4 of this document?
Yes.
Have you had enough time to speak with your attorneys, Carrington Matthews Sr. and Carrington Matthews Jr., about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this matter with your attorney?
Nope.
Are you satisfied with their counsel and representation?
Yes, ma'am.
Do you waive formal reading of the indictment?
Yes.
Do you waive any defects, if any, with respect to the indictment?
Yes.
Is it your understanding, have you been arrested on all of the charges contained within this indictment?
Yes.
And Mr. Matthews Jr., are you aware of any other outstanding warrants for these charges?
We are not aware of any.
Have your attorneys advised you of the minimum and maximum sentence for each charge that you are pleading to?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence?
Yes.
Let me tell you the sentence quickly.
Oh.
As to count 1, which is conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, the state's recommendation is 20 years to serve 9 years in custody, the balance of 11 years on probation. As to count 3, armed robbery, based on the negotiations, the state will reduce the armed robbery to robbery and offer a sentence of 20 years to serve 9 years in custody, concurrent with count 1, the balance of 11 years on probation. As to count 4, aggravated assault with a deadly weapon, the state will recommend 20 years to serve 9 years in custody, concurrent with counts 1 and count 3, balance of 11 years on probation. As to count 5, aggravated assault with a deadly weapon, the state agrees to null pros or dismiss that count. As to count 6, possession of a firearm during the commission of a felony, the state's recommendation is 5 years to serve, consecutive to counts 1, 3, 4, 14, 15, and 44 to be suspended. As to count 7, possession of firearms during the commission of a felony, the state will null, prosecute, or dismiss that count. As to count 14, which is armed robbery, will reduce that to robbery, 20 years to serve 9 years in custody, concurrent with counts 1, 3, and 4, balance of 11 years on probation. Count 15, armed robbery, reduced to robbery, 20 years to serve 9 years in custody, concurrent with counts 1, 3, 4, and 14, balance of 11 years on probation. Count 16 will be null, pros, or dismissed. Count 17, that count will merge with count 15. Count 18 will be null, pros, or dismissed by the state. Count 19, possession of a firearm during the commission of a felony, will be 5 years to serve, 5 years to serve consecutive to counts 1, 3, 4, 14, 15, 17, and 44, but concurrent with count 6, and that will be suspended. Count 20 will be null, pros, or dismissed by the state. Count 21 will be 5 years to serve, concurrent with counts 1, 3, 4, 14, 15, 16, 17, 19, and 44. Count 22 will be null, pros, or dismissed by the state, as well as count 23 will be null, pros, or dismissed by the state. Count 44, possession of a weapon by an incarcerated individual, will be 5 years to serve, concurrent with counts 1, 3, 4, 14, 15, and 17, and counts 45 and 46 will be null, pros, or dismissed by the state. Do you understand that that's the state's recommendation?
Yes.
Do you understand that the total sentence is 25 years to serve 9 years in custody with a balance of 14 years? 9 of those 14 years will be served on probation and 5 years will be suspended. Do you understand that?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
And the court can sentence you to the maximum of each charge and can run those charges consecutively, one after the other.
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions without being subject to revocation for the balance of the sentence?
Yes.
And do you understand that there were several special conditions of probation that you must adhere to, which are contained within this documentation?
Yes.
And have you had an opportunity to go over each of these special conditions with your attorneys?
Yes, ma'am.
And did you also go over with your attorneys your sentencing acknowledgments regarding this plea agreement?
Yes.
And is this also your signature on this documentation with your attorney going over each of the each of the special conditions of probation?
Yes.
And did you fully understand the special conditions of probation?
Yes, ma'am.
Ms. Hilton, can you pass that document up to the court, please? Thank you.
Did you want to review before I continue? Did you want to review before I continue?
No, that's fine. Go ahead.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that you are not a United States citizen? A guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the courts, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or the Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? And after each right, I'll ask you to respond. The right to trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assistive counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case,
Yes.
the right to presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charge against you proved beyond a reasonable doubt,
Yes.
and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
With respect to indictment 22 SC 183572, how do you plead to the charges in that indictment?
I plead guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of charges against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes.
And do you understand that you have until the end of this term of court to file a motion seeking to withdraw your guilty plea?
Yes.
Your Honor, if this case were to go to trial, the state would expect, or if we were to continue with trial, the state would expect to show, or evidence has shown and will show, that Mr. Huey conspired with others to participate in YSL through a pattern of racketeering activity, and multiple defendants, as well as unindicted co-conspirators, have committed overt acts to further this conspiracy, to include drug sales, aggravated assault, and murder. Also, it includes posting on social media, asserting the violent nature of and the dominance of Young Slime Life, AKA YSL. Specifically, Mr. Huey himself participated in 2 robberies. He posted on social media and he engaged in text messages with his fellow co-conspirators. On April 26, 2019, Mr. Huey, along with another individual, armed around Mr. Dewan Maynard, at an apartment complex located on Masargo Drive in the Buckhead neighborhood in Atlanta, Georgia, Fulton County. He robbed Mr. Maynard at gunpoint and pistol whipped him. Mr. Huey was wearing a very distinctive yellow jacket. He stole a ring, a necklace, a luxury wallet, and other items. He then fled the scene in a black Mustang. Portions of this robbery, Your Honor, were caught on surveillance video. After the robbery, Mr. Huey was seen on his social media account with the ring and necklace that is identical to the items that were stolen from Mr. Maynard. Additionally, on Instagram, or on social media, there were several pictures of Mr. Huey photographed next to a black Mustang. There were several pictures. Lastly, there were pictures of Mr. Huey on his social media wearing the same distinctive yellow jacket that was seen on the surveillance video. Based on that evidence, Your Honor, arrest warrants were issued for Mr. Huey. While on bond for the April 2019 armed robbery, Your Honor, On October 1st, 2020, Mr. Huey went to the apartments located at 250 Fulton Street, Atlanta, Georgia, Fulton County, to meet with Mr. Gary Holloman. Gary Holloman, who is now deceased, told law enforcement officers on the night that he was robbed that Mr. Huey, who he knew, asked to meet with him so that Mr. Holloman could give Mr. Huey money to put on another co-conspirator to Aquarius Mender's books or commentary at the Fulton County Jail. Aquarius Mender, who is a co-defendant and co-conspirator, is the nephew of Gary Holloman. Mr. Mender and Mr. Huey were friends or are friends. Mr. Holloman agreed to meet with Mr. Huey at the location. While at the location, Mr. Huey, along with another individual, approached Mr. Holloman. One person had an assault rifle. They took from Mr. Holloman his car and his money. They also robbed another young lady by the name of Misha Coppage. Mr. Huey and the other unidentified individual fled the scene and left. Mr. Holloman immediately called the police. When police arrived, Mr. Holloman was able to use another cell phone to track his phone. He was able to track that phone going in the direction of I-75 South, and ultimately that phone was located on Oak Drive, which is in the Cleveland Avenue area, which is the area or territory for Young Slime Line. Also, Mr. Holloman was able to show police officers the social media pages of Mr. Huey to identify him. Initially, the police marked this case as an information, and the case was not initially investigated. However, about 1 month later, Mr. Holloman went to the police headquarters, spoke with investigators. He was able to pick Mr. Huey out of a photographic lineup. Subsequently, investigator Marissa Viverito, who was formerly with the Fulton County District Attorney's Office, found a jail call with Aquarius Mender, Mr. Mender's mother, as well as Gary Holloman discussing the robbery, and Mr. Holloman discussing what occurred to him. Arrest warrants were taken out for Mr. Huey. He was initially arrested in November of 2020. During that arrest and pursuant to a search warrant, his home was searched. In that search, they found 2 rifles, 2 rifle handguns. Also, they found items belonging to an individual by the name of Chandler Durham. During that search warrant, they seized Mr. Huey's phones, and pursuant to a search warrant, did a search of those phones. Upon seeing the items from Chandler Durham, investigator Viverito checked the Atlanta Police Department database to find out if there were any police reports associated with the Chandler Durham. She found a police report from March 12, 2020. In that report, Chandler Durham reported that while he was working at a music studio, his car and additional items to include a luxury bag were stolen. After finding the report, investigator Viverito went through the contents of Mr. Huey's phone, and she saw a few text messages of note. She saw a text conversation on March 12, 2020 between Jeffrey Williams and Mr. Huey. Jeffrey Williams told Mr. Huey that they needed to take that shit back. Mr. Huey denied involvement in taking the items and blamed it on another person. Mr. Williams then told Mr. Huey in this text message, if he doesn't take it back, he's going to die. Also found in Huey's cell phone were 2 incidents in which Mr. Huey and Mr. Williams were in conversation with each other regarding rival gang member Rayshawn Bennett, aka YFN Lucci. On January 19th, 2020, Mr. Williams sent a flyer to Huey with a performance location of YFN Lucci. The text message read, handle that tonight, slapped. Then Huey responded, slap. Your Honor, based on the state's understanding, slap means slime love all the time. Then on September 2nd, 2020, Mr. Huey sent a flyer to Mr. Williams with another performance location of Mr. Rayshawn Bennett. Mr. Williams texted, flatty, handle, and stay very low. Huey's response was slapped, and for sure, I've been out the way. And appreciate you for everything, my brother. Never about money with me, I'm built on loyalty. Williams' response was slap, handle that, I got you. In 2021, we were able to recover another phone from Mr. Huey after he was subsequently arrested on grand jury warrants. When we did a search warrant of that phone, there was additional communication between Mr. Williams and Mr. Huey. Mr. Huey told Mr. Williams on November 14, 2021, you know I'm ready to handle the business and go sit down if I got to about any one of y'all on my mama. This text message followed information that was provided to investigator Viverito by Kenneth Copeland. Kenneth Copeland, during an October 2021 interview, advised investigator Vigorito that he was aware of a potential plot to harm another another rival gang member, Kelvin Watts, also known as Shell Kel, at a venue, Diamonds of Atlanta on Northside Drive. Mr. Coleman advised that he was aware that Huey was to participate in this plot to harm Watts, and he attempted to tell Huey not to participate. Lastly, Your Honor, on February 18, 2022, while housed at the Fulton County Jail, along with Aquarius Mender, they were both housed in the same cell. There was a search of that dorm specifically, and inside of the cell, there was a shank and an illegal cell phone inside of their cell that they shared. And based on what we know from other evidence that we have, that cell phone was used to communicate with other YSL members. Your Honor, this is the evidence that we believe would have come out had we continued with trial. Given where we are, Your Honor, and the charges, we made a decision to resolve this case with Mr. Huey for the offer that was relayed earlier, Your Honor. And I have a copy.
All right, and with regard to the offer, I just wanted to be clear that on counts 6 and 19, which are possession of a firearm during the commission of a crime, while this 5-page plea agreement document reflects that those are going to be served on probation, the intention of both parties is that those 2 counts be suspended.
Yes.
Is that right?
Yes, Your Honor.
Okay,
Yes,
and in your global sentence, it says 5 years suspended, and so I assume that that's what y'all meant by that.
Yes, Your Honor.
Okay. All right. Mr. Matthews?
Yes, Your Honor. Good afternoon to this honorable court, Your Honor. I'd like to begin by expressing to the court that we emphatically and categorically deny all of the recitation that's been presented by the court with respect to some of these allegations that's been laid out by the state. However, we do recognize that there are enough factual allegations in the recitation to support each and every count to which Mr. Huey is pleading this afternoon. So we do stipulate that there is enough to move forward with this plea. For those reasons, Your Honor, we are standing before this court to talk to this court about the acceptance of responsibility with respect to Mr. Marquavius Huey. Your Honor, Mr. Marquavius Huey was born in Atlanta, Georgia. He lived in the Jonesboro South community, a neighborhood project in the Atlanta community. He grew up there. He's seen a lot of things in his short 28-year life. His father was murdered in 2010, and he's been without a father for a number of years. He's been raised by his mother as a single parent. He has a number of siblings. There have been times when Mr. Huey and his mother and his family have been homeless and have lived out of a car. So he's had a very, very hard life as it relates to his upbringing. Notwithstanding that, Your Honor, he did manage to graduate from high school. Mr. Huey, Your Honor, now has 2 children. He's 28 years old. He has 2 children. He has a 5-year-old son, Your Honor. He has a 2-year-old little daughter that was born in July of 2022. He has never met or seen his daughter in person until today, as she's here in this courtroom. He recognizes that choices puts him before this court in this case. Your Honor, we are asking this court to take into consideration that he has no prior felony convictions. I've had a very long time to get to know Mr. Huey because I've been with Mr. Huey on a regular daily basis during the week since January of 2023. I've got a chance to know him. I've got a chance to work with him on his case regularly. And he wants to, when he gets out of custody, Your Honor, he wants to do a number of things, two in particular. He wants to start and become affiliated with a nonprofit organization where he can be able to talk to young children, teenagers, because he was a teenager when he lost his father, and things began to take a turn for Mr. Huey. He wants to be able to tell teenagers, young boys, young Black boys, he wants to be able to say to them, don't do what I did. And you have another way in which you can go. And he wants to be able to share his experiences in that way. I have linked Mr. Huey up with an organization called Young Generation Movement. And I've known that nonprofit organization and the founder of that organization for a long period of time. He's also present in this courtroom. And I've linked Mr. Huey up with them so that when Mr. Huey gets out of custody, he will be able to have an organization that can mentor him, that he can align himself with, where he can begin to engage himself with anti-violence nonprofit conduct and mentoring other young people. He also, in terms of being able to earn an income, because he is now, Your Honor, if this court accepts this plea, Mr. Huey will now, for the first time, be a convicted felon. He is not first offender eligible. He wants to get his commercial driver's license, Your Honor, and he wants to get a trucking company and be able to earn a living for himself because he recognizes that it's going to be a challenge for him to be able to go out and apply for jobs and be able to get income by getting an employer to hire him. So he's going to focus and target himself to be able to fend for himself so that he can take care of his young children that he has helped to bring into this world. Your Honor, we are here before this court because it's an acceptance of responsibility. We recognize that this has been a very long, enduring trial, and we have come to a point where we have painstakingly negotiated with the state of Georgia, and we've come up with a negotiated resolution that we believe is one that is fair. We believe that is sufficient to recognize the seriousness of the charges that are before the court. And we believe it's one that will cause Mr. Huey to be able to see the light of day in a reasonable period of time. Mr. Huey has been in custody. I'd like to enter into the record, Your Honor, as Defendant's Exhibit 1 for sentencing purposes, a proof of incarceration from the Fulton County Sheriff's Office. Mr. Huey, through the computations of the various times when he was arrested on these charges and released, and from the time that he's currently been in custody to the present, he has approximately 4 years under his belt against that 9-year sentence, and that 9-year sentence is parolable. So we're going to enter that as an exhibit before the court.
All right, that'll be Defendant's Exhibit 1 to this plea hearing. And as you know, and as I'm sure you have shared with Mr. Huey, it's ultimately the Department of Corrections that calculates the time served portion of the sentence. So it'll ultimately be up to them, but I will include that as a part of my sentencing sheet as well.
Thank you, Your Honor. Thank you. It's been an absolute pleasure and honor to represent Mr. Marquavius Huey, along with my son, Attorney Carrington Matthews Jr., who also would like to address the court at this time, Your Honor. So we're asking this court to accept the negotiation that has been represented to the court and Mr. C.J. Matthews.
Yes, good afternoon to this honorable
Good
court.
afternoon, Mr. Matthews.
I've been gracious with this opportunity to represent and serve Mr. Huey. Mr. Huey is an honorable young man. Mr. Huey does not allow his mistakes to define him, but he is remorseful, Your Honor. He has learned, grown, and became a better man during this trial. Mr. Huey will have a release date, Your Honor. And I'm confident in him that he be a working class citizen in society when he is released. We thank this honorable court and we respectfully ask this court to accept this plea on today.
All right, thank you, Mr. Matthews. Mr. Huey, I am sure that Mr. Matthews Sr. and Mr. Matthews Jr. have, I know that they have been working with you and negotiating with the state for over, I'm sure the entire course of this trial and proceeding, but very, very hard over the last week and a couple of days to get where we are right now. And I know that you know that given the severity and the number of charges that you were facing, that had you been convicted of all of those charges at trial, you were looking at the possibility of 3 consecutive life sentences, plus I think about 100 years after that. So the fact that the state is recommending jointly with your attorneys that your total sentence be 25 years with 9 of those to serve is, it's frankly remarkable, and something that you should not take for granted or take lightly at all. These are very serious charges, and I hear what both Mr. Matthews have said about the challenges facing you in your life, and I am sorry for the loss of your father. One would hope that to have anybody that they love taken from them in a violent way like murder might have an impact upon their lives that would lead them in the right direction, but it's not particularly surprising that sometimes that's not what happens and it goes in a worse direction instead. I hope that with your age and with having really been faced with the distinct possibility of spending the entirety of the rest of your life in prison, the fact that you are getting this opportunity is not going to be wasted. I hope that you appreciate what the Matthews have done to go out of their way to line up somebody to be looking out for you when you are released from prison. And I want to ask you, just like I have asked both Mr. Nichols and Mr. Ryan, is this your decision to enter this guilty plea? Because no matter what your attorney's advice is, it's ultimately up to you whether to plead guilty or continue with the trial. So is this what you want to do?
Yes, ma'am.
All right. And have you had enough time to consider all of the different scenarios and to discuss everything you wanted to with your attorneys?
Yes, ma'am.
All right. All right. I think it's very clear that this plea is to your benefit, considering the potential downside of moving forward with the continued trial. I find there to be a factual basis to this plea. I appreciate the fact that y'all have stipulated that there is a factual basis. And I find the plea to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences, and I will accept it as such. And I will sentence in accord with the negotiated recommendation. I'm not going to read everything out again. We've thankfully got it in writing for the sentence sheet, but in accord with what was put on the record and what is reflected in this this document, with a total sentence of 25 years to serve 9 in custody. balance of 14 years. After that, 9 of those on probation and 5 suspended. And I'm going to impose the special conditions that you have already acknowledged and acknowledged that you would abide by. And, somebody with a high school diploma, which is more than a whole lot of people ever achieve. So you've already achieved and proven that you can achieve good things. And who is only 28 years old, and who can really look down and already see the light of day for a release date. You need to make sure that during your time incarcerated that you don't pull any of the kind of thing that you have been, that you actually are pleading guilty to, at least some of, by having contraband or in any other way getting in trouble, because that's not going to bode well. I am going to recommend a transition program for you. I know that there's a lot of different job training available in our correction system, so I hope that you take advantage of that. And whether it's a commercial driver's license or whether you find something else that you want to do while you're in there, be making good use of your time while you're in there and furthering yourself. And you have had a fine example next to you for the past 2 years of what somebody can do with their lives. So don't forget about that, and be the father that you need to be and that you ought to be to your very young children. They're still going to be very young when you get out. And please make sure that you abide by all your probationary conditions, because if you don't, then you're going to be back to see me. And because I recognize how much of a break you're getting right now, I'm probably not going to be as lenient if you come back before me again, because you are getting a huge opportunity to turn your life around. Okay.
Yes, ma'am.
All right. So that's the sentence of the court. And I want to wish you good luck and good fortune. You can get through the next few years, and then you can have the rest of your life to do good work with.
Can you address the court?
Yes. I should have asked that. I'm sorry.
That's okay, Judge. Thank you.
I want to thank the court and thank God. And I want to apologize to my kids, my family, and everybody who done supported me in this stressful process. And, I plan to do my time, come back, be a better man.
I'm glad to hear that. Thank you.
Your Honor. Thank you.
All right. All right, let's take a recess. Hmm?
Ooh. Mm, 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 mm. What's good? What's good? What's good? Well, well. Few things. She said recess. I don't know if it's recess for today. It probably is. She didn't give a time frame, but we're just gonna let it sit there for a minute because we're not sure. Okay. But I was able to get that Mr. Burns Rule 22, that modification of it. I mean, I could have gotten Coach Sylvia's too, but it's pretty much the same thing. That's what they said. So, um, so listen, right? So I had to add another C. I've got the main C. Um, and these are definitely consolation, consideration, concession, and correction. Please, right? Now I'm going to speculate that if there are any press conferences or interviews that are going to be held with regards to the latest development of this particular trial, I'm pretty sure we're going to hear from either all sides or a side at least that um, they did what was best for their client in the case, right? So, and I had forgotten how informative the um, circumstances, or it got to kind of read like a proper of plea deals, how much information it gives you in a few minutes, right? Instead of you having to go through the whole trial or what have you to see whatever evidence, for a particular person or whatever, it pretty much gives you a sum. And I'm talking about the portion that we hear Miss Love reading in court, right? Um, Different states call it different things, but nonetheless, um, that's pretty much what it is, right? It's pretty much a statement of facts. And yeah, so and when dealing with plea agreements, there's just certain things you have to stipulate on the record, right? That hey, okay, either I agree. You're gonna say I agree, but you're gonna make if you but that doesn't mean that you can't say I'm doing what's best for me or yeah. But most of the times, if not all of the times, they're going to stipulate that the evidence would show that their client is guilty, right? It is what it is, and pretty much you take a plea, and I'm not saying that 100% of the time that people are guilty that take a plea. That's not what I'm saying, right? But what I'm saying is majority of the time that a person that takes a plea is guilty, and more than that, they know that the evidence will, implicate them in the crime in which they're being charged for. So that's Oh Lord. I mean, it's like they just keep 1, 2, 1, 2, 1, 2, 1, 2. So everybody is winning. In case you want to know who's winning. Matter of fact, let me do a poll on that. Let me do a poll on that. Who's winning? Yeah, we're gonna talk about some shit today, though. Perfect. Oh my gosh. Listen, you know, commentary is meant to be commented on, right? So if anything you put out, put out, right? Anything you put out is subjected to be scrutinized, right? Criticized, made fun of, talked about. But that's everything, right? So if you get up here and put out some ignorant ass shit, some illiterate ass shit, yeah, it can come back to you. So people need to keep that in mind. Sometimes I think people think that criticizing commentary is only their right, right? That's not what it is. That is not what it is. So you know if I'm saying that, you know I got sent some funny shit. Oh my gosh, baby. Listen here, the meme master. No, well, I got another meme master too. Ain't that hell? Oh my gosh, but they do clips. Oh my god, they like what the fuck? Let me move my nose real quick. All right, sorry about that. Y'all see I had somebody on hold, honey. Oh Lord, I have been on that. Lord, have mercy, the wrong area. Oh, you got to be kidding me. You got to be freaking kidding all of my darn body. But yeah, I was trying to blow my nose at the same time. Child. Mm. Oh boy. But you know the way to avoid somebody talking about your ass and laughing at you is to leave people alone. That's always, a good method. I'm gonna post that message on the board. Always the subject. Mm. But again, when you crazy, you just can't go on about your business, honey. Yep. And although I'm not a doctor of craziness, at least I've done some work in that area where I'm able to recognize crazy when I see and hear it, right? So hey, I ain't just out here blindly calling people crazy. I'm not meeting. No, I'm not doing. I don't have to do mold standards because I don't have mold standards. I don't have to do that. But anyway, let me stop cutting food and get back to serious business. This is why I sell thing, right? So, um, it's a lot going on, right? And I'm gonna tell you what I think happened. Okay, soon after, and very soon after, it was up in the air about. And let me go back to visit that moment because I don't think I don't think the judge was, and I may be wrong because y'all know I be in and out and I be sleep. Because I could just wake back up and pick up with the you know with regards to the legal commentary, right? I don't need no study. I could just wake it right up and get into it, right? So I don't know if the judge was questioning whether or not she should do a um whether it should be a mistrial. Oh, I think. Oh, wait a minute. Hold on. Well, be killing me. People be calling you, asking you to get in more debt. Talking about, we calling to offer you a loan for 6 point whatever percent. Girl, if you don't got my damn phone, 25, I don't need nothing. No. Chicken $25 and all this here. No, I don't need all that. Hell. What? Girl, you better get on. Listen here. But I need to go back and play that moment where, let me find, because I want to know. I don't know exactly what she said on that stand. We need to hear exactly what it was. What was that boy named? Woony Lee. Okay. Woony Lee. Yes. I just like to make sure my theory is correct, and I have to, that's the way I like to test it. Hold on. Judge. Some may say, Andrew, why you go through all of this just to, you know why? Because it's called, can't turn it off. It's called not just saying shit for likes, clicks, and views, not just saying shit to stir the emotions of people. Not, not, and one, who puts out bad, okay, a lot of y'all, never mind. Never mind. Hold on. I'm not sure she said that. That's the way it was packaged up. What did she say?
Insert error into this trial to make y'all ask for a mistrial so that they can try this case again. I think it is continued, and I am sorry. Y'all have, this gigantic, ginormous universe of evidence that maybe if you narrowed down, you would not be making these kinds of mistakes. But I believe that to be a mistake.
Your Honor,
So I'm going to deny a motion for a mistrial with prejudice. That one, I don't believe that the facts bear out. Would you like a mistrial without prejudice?
yes.
You would? Who else would? That means, of course, that the state would be free to try every one of y'all again.
Judge, just a moment.
Sure. Matthews.
Yes, Your Honor. Good afternoon to this honorable court, Your Honor. I'd like to begin by
Let me find a longer clip. That's not the whole thing. Let me, because I don't know if she wasn't just being smart at the mouth. Hold on, let me get to it. I'm gonna get down to it now. Oh, that was it. Okay, hold on. Let me see what it said. When I tell you, because what I was going to say is gonna play right into what I was um already thought. I just need to confirm some things. Hold on. Oh, child. This is like riding a bike. Okay, I didn't see all of this with Glanville and all of that, so I want to see what was said back then. I want to see the rest of what that end of what I just played, and I want to, and I'm gonna go to the the attorneys discussing the plea deal. Let's see if we were right.
Right now, the judge in the long-running YSL RICO trial is deciding whether that trial should come to a screeching halt.
Atlanta News First anchor and attorney Joy Lim joins us now following what's happening in the state's longest running case ever.
That's right, Blair and Sean. Well, Judge Paige Reese Whitaker is considering another motion for mistrial. And after hours of waiting, we just learned that court is now set to reconvene at 9:30 tomorrow morning. And remember, Judge Whitaker is now the third judge in this case. The first judge, Earl Glanville, was recused from the case after defense attorneys claimed that he was biased, and they called for a mistrial on that basis. Well, the latest call for a mistrial comes after a state's witness on the stand accidentally read the hashtag Free Quay from an unredacted version of a paper exhibit instead of the redacted version displayed on a monitor. And attorneys for two of the defendants argued that that evidence was prejudicial because it implied that their clients were locked up. Well, Judge Whitaker also criticized the state for their presentation of evidence, indicating she would consider granting a mistrial. Here's what she told prosecutors on Wednesday.
What I'm trying to do is fix your sloppiness so that everybody won't have wasted, 10, 12 months of their lives in this trial.
Now, we've also confirmed that attorneys for several defendants, including Diamante Kendrick, met with District Attorney Fonnie Willis to discuss a plea deal. Jury selection in the trial began in January of 2023, with dozens more potential witnesses still expected to testify. Blair?
Joy, thanks so much. DeKalb County.
Then walk us through what you think of this plea deal you were able to negotiate.
Well, insofar as it resolves all of these charges against Mr. Nichols, I think it is an exceptional result. It's an exceptional result for the following reasons. No murder charges, no gang charges, no factual acknowledgments required by the state, no other charges except for one conspiracy charge that was factually underpinned by convictions that Mr. Nichols already had from almost 6 years ago. So that result, I think, is an excellent result for him and resolves all of these cases. The RICO charge in this case was a RICO conspiracy. And underlying the RICO conspiracy were all the 100+ factual predicates, some of which have already been resolved by and against Mr. Nichols. Some of them we hadn't even gotten to. And I don't believe the state would have been able to prove Mr. Nichols' responsibility for those predicate acts. So this was, we were in a conspiracy. We acknowledge that factually the underpinnings of the RICO conspiracy are satisfied by what already was presented and what he had already pled to, but nothing else. No, as we said, no murder, no guns, nothing else. No gang charges. Listen, there is no gang charge. He did not acknowledge being in a gang, being responsible for being in a gang, committing any kind of violent act on behalf of any gang. Yes, I was in a overall conspiracy. Thank you, see you later.
You were behind kind of the original mistrial motion that led to this flurry of negotiations.
Yes.
Just walk us through kind of how it went from that to taking a plea.
Well, the state made several errors in the case into which we had to ask for a mistrial. So we were satisfied that the judge, she heard us and our motion and asking for a mistrial, and that, errors cannot be repeatedly occur in front of the jury and inadmissible evidence being heard by the jury. And so we're glad that the judge, heard our motion and said, do you want a mistrial, and will you take a mistrial without prejudice? And, and then we went into negotiation, and we're pleased with the outcome of our negotiation.
How relieved are you after, being part of Georgia's longest trial that, your portion of this at least is over?
Well, now we can wear B suits and A suits. No. How relieved are we? Once you're in that routine and once you're there with your fellow lawyers and your fellow co-defendants, I mean, that it's almost ritualistic. I mean, we were there every day. We were working every day. So, I mean, we're relieved because the result for Mr. Nichols was the right result. Now we have to deal with the rest of the world. They can release us from our kidnapped status.
You gonna miss courtroom one thing?
Yes and no. Yes, clearly. But I'm glad that all of us could work that resolution. And that resolution, again, from Mr. Nichols was no gang, no factual acknowledgments, no murders. So he can go on about his life and get out. He's a young man. He's a nice looking man. He's a smart guy. So I'm hoping that this projects him forward and doesn't leave him in the lurch.
I'm gonna say you're almost, sorry.
I saw that you choked up during.
I did.
And this had to be a difficult decision because during this time, he's become family in a sense.
Yeah, very much
How
so.
difficult was it actually deciding not to go with the mistrial without prejudice versus go ahead and make?
Yeah, but that allows him to do it again.
Yeah.
That allows the case to continue and doesn't resolve the case and doesn't give any sense of finality. Without the factual acknowledgments, without agreeing to the state's factual contentions, this ends the case. I mean, it's over. A mistrial without prejudice means it's subject to recurring. And there's a whole other group of severed defendants that are still out there and awaiting resolution. And I think we're in the best posture at this particular point with this particular judge in the 2 years that we've been litigating this and everything that has happened to strike at this particular point.
You were talking about, you guys do a word of the day. Or
Yes.
Can you
Yes, we
talk
do.
about that and kind of what's next for him once he gets out?
Well, can I tell you that he is a very receptive young man. He's like a sponge. He doesn't have a formal education. He doesn't have a consolidated family upbringing. But he's very curious and he's very smart. So we would use a word or get a word a day and we would define it. We would use it in a sentence. And, you can see his intellectual curiosity. He's a really good kid and a smart kid. And I want him, truly.
It's true. I mean, we've spent 2 years, over 2 years with our client. And like Attorney Hard was saying, he's intelligent and he's so much more than unfortunately what comes out during a trial process. And, the word a day, he asked the word a day. Myself, Attorney Harvey, we go back and forth of picking a word and we teach him the pronunciation of the word. And then, 2-3 weeks later, he'll use a word that he learned, 2-3 weeks before and he keeps it going. And so he's a great individual and we're glad that this is over for him. It's been 2 years too long.
But he's also developed a pretty sophisticated understanding of the system. I mean, he can look at me when something happens and go, hey, this is what happened. This is what should happen. I know what is going on here. So he, like I'm saying, he's a sponge. I mean, let's bring these kids forward.
This trial has been a learning process for all involved in YouTube and media and also in the prosecution. What are you hoping to come from all of the things that you've shared and done with?
Well, let me just shout out to the YouTube folks. I mean, we all watched it. We all watched the commentary and we love the commentary and we point out the commentary. So we've had a good time seeing the reaction to what has happened in the courtroom. And, people have an idea of what happens in court, that it's always, inflammatory, it's flamboyant, it's this, and something always interesting has happened, except for the days and days we have with phone records. And so somebody up there saying, well, this is the phone number that's associated with, Miss Johnson. And really, what was the name of that? What's the address? And let's write that down. I mean, it's just drudgery. It is, section after section after section. And I know it's all part of a puzzle, but I hope that everybody understands that it is not all excitement, and that you've seen how deeply everybody has dug into this case and all of the things that have been litigated week after week and day after day after day. We appreciate what everybody says.
Any message to the rest of the defense attorneys still fighting for their clients in this case?
Good luck.
Do you think this plea is going to affect any of the rest of the case moving forward?
Well, something, I think we were lucky. Not lucky. Let me try to find a better word. We were able to resolve our case in a different fashion than what I understand has been put on the table for others. When I say we resolved it to a single count, we resolved it without those other acts, we resolved it without any factual acknowledgments. If you have been following this closely, every other person in this case who has pled has signed a plea agreement with factual acknowledgments. YSL, I'm a member, it's a gang, I did this, I would do this on behalf of the gang, and I did this, and I agree that that's what the situation is. We were able to resolve our case without any of that, and that's the distinction. And I certainly hope, I wish the very best for every one of those young men, and including, Jeffrey Williams, who's been sitting in jail for years now. And he is an incredible talent and a wonderful young man. So I wish the best for all.
And last question from me. Do you know the 7 years? I know there's like a complicated formula of how early in theory he could
Well,
get
it's not
out.
that complicated.
Okay.
It doesn't take Einstein. Remember, E equals MC squared. Do we know that? We do know that. Do I know? No, I don't. If I knew, are you going to ask how much
I was just saying, how much time does he have left of the 7 years?
But he's got what? 24 plus 5, 29 months in. There are parole guidelines for his offense, but at the end of the day, it's up to the Georgia Board of Pardons and Paroles. And if I knew that, I would be the richest lawyer in the world, and I would be on a beach with a cocktail in one of those little umbrellas, and my pinky would be up. Okay.
I think it was kind of flip over if he had any other outstanding issues that would affect any of his probation going forward. To your knowledge, well, I know that you can't go in depth, but is there anything that will affect his?
Well, I don't know the answer to that. There is nothing related to this case. There is nothing that he has in his past that is affecting his ability to move forward and appropriately serve this sentence. Okay, his kids and his wife look forward to getting him back home.
Lil Durk, the Chicago artist whose popularity has blown up.
Okay, folks. Okay. Let me tell you what I think happened. I think. All right. So, given that little pack that I just played with regards to what the situation was the last um, in court session, right, with the judge, I don't consider that as she was considering a mistrial without prejudice. So let me tell you what I think happened, right? So this was this goes along with what I was going to say before I played the clip, and is why I put those 4 C's up there, right? I believe that the judge was active in. Now, I'm not saying this is what she did, and I'm not saying that she told her, "Oh, you better offer plea deals because you can't do that." That's not what I'm saying she did. I believe that they got a read from that judge, and we all lawyers, right? So we all know what the looks are, what the, what the unspoken alternatives can be. We know how to correct some shit. We know how to clean it up. Oh, that's another C. Damn, I got another C, y'all. Clean up. Yep. And shout out to those lawyers for being that invested into others. Right? Shout out. See, that's school folks. See what I'm talking about? That's what I'm talking about. And it don't matter whether you go to school or not. It matters if you get good people. That's all that matters. That's all that matters. Yeah, but shout out for them. Baby, I go to trembling, right? Because it ain't nothing more rewarding than to be of service to others. That's just in my opinion. When they say it's better to give than to receive, honey, that was the truth. That was the truth. Just the feeling you get from giving. It's like, man, like, oh my God. And then when you see somebody, how they respond to it, and especially if they appreciative, child, it break your heart on it. Or if you're trying to teach somebody something and you see them get it, and they apply it, and I'm about to cry now. I'm rough and tough though, so let me keep going. What I think happened is that the state knew that, they were like 5 mistrial mishaps over at this point. All right, probably Fonnie and whomever else at the top over there with the prosecutors. They heard that judge say, "I'm trying to clean up y'all shit." That's a signal to say, "Hey, y'all better come up with something." Because one, we get the same, we get paid by the same people. You don't wasted the taxpayers' dollar because your shit is fucked up. You got the jury. Some of them may get compensated by their job. Some may not. Who knows? You got defendants who they have. Let me say this: together with the state, have positioned those defendants to have a damn good, um, um, application for appeal, right? Like it's crazy, right? So you got to salvage this shit some kind of way. That's what I'm telling you. What I'm telling you. And how you do that? When a case is going bad, but you know you got enough to convict somebody. But you look over there at that jury who mainly black, you look at what's transpired thus far, and also if you are paying attention to what's going on, right, and you listening to the media, you can always use the media, what's going on in the audience, right? Us as a sample of what you can predict that jury is going to do. And if you look overwhelmingly at those who are paying attention and making comments, see, that's the difference. Not just paying attention, but those who making comments. When you actively participate, that tells someone that's doing a marketing analysis something different, right? Well, we ain't even going to that's a whole nother mindset we have to get into. But that tells us something different. And those are the ones you need to really pay attention to. You pay attention to it all, but those are the ones you really need to pay attention to. And it should tell you that it's going to be hard to convict these guys, right? So, I mean, if you think about it, I was listening to attorney Shabazz earlier, and she spoke about jury nullification. Well, guess what? Jury 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 nullification is illegal, but guess what? It can't be reversed if it happens. So you weighing a whole bunch of stuff. What up, Too Clear? What up? Welcome back. But yeah, so you wearing a whole bunch of things, right? And I believe that this was the best way to clean up what has happened, to salvage the state's case, their reputation. Don't waste any more time. I don't know how many other defendants will continue to go ahead. I mean, I don't know if their deals, if they were offered deals, the other ones, if they were offered deals, if it was, something that they could have benefited from, right? Or maybe they said they'll take their chances. Right, Too Clear. That's what I'm saying. So, you know, it's a lot going on, right? So, but I put a poll up. So those that are, because I see pretty much got the Twitter / YouTube. Hey, the ones that got ran off YouTube, they got to go over there. If you're on Twitter, wank wank. I have a poll up. I know y'all be participating in the poll, because there's no way I can have 5 viewing on YouTube and have 120 participating in the poll, right? Of course, we have our secret underground Harriet Tubman channels that we have to, communicate. Wink, wink. But anyway, so, but yeah, the state read the judge loud and clear. And I'm not saying she got in there and said, y'all better do something. No, she can't do that. And that's not what the lady did. But she did enough to let them know, I'm trying to clean up your shit. So how about you pitch in? you know, because it would have been a shame for the state to continue to go and um, continue to go and then wind up not getting any, they got the deal, right? Also, by offering these plea deals, it get it gets a lot of litigation out of the way. So those, you know, it's going to be some kind of instruction given because those defendants are no longer there. Which one was Huey too clear? Too clear. Yeah, I can't pick a side. So, but which one was Huey? Let me check on this poll. Hope I ain't closed it. The last one. Oh yeah, that was a lot. That was a lot. Hold on for 1 minute, y'all. Okay, thank you. So yeah, so you know, so they will. So it's a win-win for everybody. Now the rest of the defendants will benefit by that limited instructions, saying that, hey, well, this evidence don't apply to this person, whatever, and also explains that the um, that person that was sitting next to them is no longer in the courtroom. Yeah, and so, and because, right, plea deals are treated as statements. They're pretty much a statement, right? But it's a statement, and it's not going to be a statement against the party opponent, right? Which is an exception to hearsay. So I have to deal with that. So you don't have to deal with the confrontation clause. So if the state tried to admit those a plea deal or whatever to state facts. You remember, and the reason why I'm getting into this because I remember some of the plea deals from the people that were agreed to testify and so on and so forth, whatever. I believe some of those came in either because they either contradicted themselves or it came in as a statement against the party opponent, right? Which means that have already incriminated yourself, and I get to use it because it stipulates the facts, helps to substantiate the facts in the case. Now, sometimes those aren't allowed, and sometimes they are, but they are allowed either with the hearsay exception or the prior inconsistent statement, something like that, right? Which we went over eons ago when all this was coming up. So it's a give and take. You said I'm just trying to show you the benefits everybody is receiving and how it will impact the case going forward. I'm not sure if Young Thug is facing any more time than anyone else because, like I said, I know he's not charged with murder, but I don't know if he's charged with conspiracy to commit murder. I'm not sure. Like I said, that indictment is just too much. And I believe Love is where she wanted to be. One-on-one with Thug, yeah, I think that the judge will just mention the settlement has been made with the defendant. He's calling next witness. Yeah, you have to. She has to give a limited instruction, because when it comes to court cases, hearings, while it might sound very, very small, optics matter. So if the jury look over and see that the defense area is thinned out a bit, they're gonna have a curiosity, right? And you don't supposed to do anything that will confuse the jury. Okay, so you can't confuse the jury. So, but as y'all see, you getting a chance. I mean, now this particular case, is a legal lesson if I ever seen one. You getting the preview of just about every kind of damn plea agreement there is, and one that's been given for all kinds of reasons. You've seen them being admissible when generally they're inadmissible. So, but I'm trying to see if there was another press conference like the one we just saw. This is wild. But I know those guys are glad to know the final disposition, right? That's another thing a plea agreement will do. It will make you go to sleep just a little bit more better at night, right? Because you already know what the deal is. And that one that's 20 years old, he's already doing life. Like for what? What he do? He's a baby. And he looks like a baby. Like, what did that baby do? But with the attorney that spoke on at that press conference I just showed, it was good that he negotiated that. Hey, no gang acknowledgement, and I mean, if all of them could have negotiated something like that, I'm talking about the ones that took a plea, then that would have been something good for all the defendants because they are being accused of being a gang, right? But the state has enough, uh, enough pleas that, uh, enough pleas with people agreeing that they were a gang. And see, you got to get up pretty early in the morning to get one over on a prosecutor. And now that I think about it, she probably all the plea agreements is to confirm or substantiate pretty much what's in the indictment that pertains to that defendant, right? So by getting on paper that you are agreeing that YSL is a gang, that is, if you can get that agreement in, and good Lord, honey, some of the defendants gave her reason to get them in, or Lord. And also, it was an admission by party opponents, so it incriminated them in the case that they're in, right? So when it's uh, an admission like that, it's a statement like that, it's liable, like more likely to be admitted. Y'all, I'm sorry, I'm just trying to get comfortable. Oh my God, I've been stressed out. I have been stressed, honey, stressed. So, yeah, let me add a little Dirk to our little lineup today because I have while I was sitting there, I don't know if y'all saw me add it to the list. Let me see if I can find his charges. Hold on. Oh yeah, I got Mr. Dennis's thing too. Let me see if I can get. Murder plot. Okay. Let me play this. Details. Okay. Let me play this. Darkness, my baby. I mean, they getting all my people. Lord have mercy. I love some dirt. I don't know if songs like that, but I know the ones I like.
For hire. Popular rap artist Lil Durk in a Miami federal courtroom today charged with murder for hire.
U.S. Marshals arrested a Grammy-winning rapper whose real name is Dirk Banks in Broward County Thursday.
NBC6's Marissa Bag is live outside the federal courthouse in Miami to explain why he was arrested in South Florida, even though the alleged crimes happened out of state. Break this down for us, Marissa.
Jawan, according to the FBI, U.S. Marshals caught up with Banks in Broward County yesterday as he was trying to flee the country. He spent the night in the Broward County jail and then came down here to Miami, went before a federal judge just a few hours ago on 2 counts of murder for hire.
Dirk Banks, the rapper known as Lil Durk, who has collaborated with artists like Drake and Morgan Wallen, appeared in a federal courtroom today accused in a murder for hire scheme. Cameras are not allowed inside federal court.
He will not be commenting at this time.
We were just outside the building as his family gave no comment and hopped inside of a black SUV. Federal agents accused Banks of paying for the attempted revenge killing of rapper Quando Rondo in Los Angeles in 2022. The gunman, seen here in surveillance images, instead killed Rondo's cousin. 5 members of Only the Family, or OTF crew, a hip-hop collective that Banks started, are charged as co-conspirators in the alleged murder for hire plot. Officials claim the LA shooting was carried out in retaliation for the 2020 death of Banks' best friend, rapper King Von, in Atlanta. Banks denies that OTF is a gang, but the FBI said in court filings that, quote, OTF members engage in violence, including murder and assault, at the direction of Banks and to maintain their status in OTF, end quote. Banks' music has become more popular in recent years, and he has a foundation that gives back to the community in his hometown, Chicago. But that and his music career are on pause as he faces these serious federal charges.
And Banks will remain in federal custody as agents work out how they will transfer him back to California, and he'll go before a federal judge there in the coming days. Reporting live in downtown Miami, Marissa Bag, NBC6 News.
Grammy Award-winning rapper Lil Durk was arrested.
Okay. Now, here's some information about the murder for hire plot. So I have 2 videos on that.
Durk has been arrested and charged with a murder for hire plot. The Chicago native, whose real name is Durk Banks, was arrested in Florida by the U.S. Marshals Service. The 32-year-old's arrest comes as 5 other people in Chicago were arrested in connection with the investigation. According to the complaint, Banks and his co-conspirators allegedly worked together to, quote, track, stalk, and attempt to murder a target at a Los Angeles gas station, firing at least 18 rounds into the person's vehicle, striking and killing a passenger in the car. Banks made his first court appearance this afternoon in Miami. Banks' lawyer asked for privacy after leaving court, telling ABC, quote, "We will not be commenting at this time." I want to bring in ABC News contributor and Sirius XM radio host Mike Muse and ABC News contributor and criminal defense attorney Shauna Lloyd for more on all of this. And Shauna, I want to start with you on this. The charges against these men include conspiracy to commit murder for hire and use of a machine gun in a violent crime resulting in a death. The most serious charge carries up to the death penalty if convicted. So, I mean, I know it's early, but how do you see this playing out?
You know, Alex, this is a very serious charge. Conspiracy is one of those charges that all it takes is voluntary knowledge. So as long as you had any conversation with two or more about something, a plan to further this plot for hire, and it resulted in a death, you are looking at those either life imprisonment and up to the death penalty. So it does not take a lot to be convicted of conspiracy charges. Now, they do have to show that he was voluntarily a part of this conspiracy, and they're going to have to show that he knew what the end goal of the conspiracy is. And so that's the burden. But conspiracy does not take as much as other charges. So this is a very serious crime.
Mike, you know, one of the things that strikes me about this is Durk has long touted himself as the voice, especially from Chicago. He's noted his connection to the trenches, but also he's had a kind of a stellar 2024, appearing on some hit TV shows and new music on the way. He just celebrated a birthday. So I'm curious. I mean, how is the music and entertainment world processing this news? I mean, that had to be a huge shock.
Yeah, it was very much a huge shock, and particularly coming off the Grammys when he had the song "All My Life" with J. Cole, which is pretty much one of his biggest singles that he's had to date. That had incredible commercial success. Lil Durk is part of what is called the drill movement in Chicago, and so every region in the United States has a different sound when it comes to hip hop. And so Lil Durk was really at the forefront of the drill music, which is controversial. It is very rooted in gang culture. I don't think any of us involved in the music industry, entertainment industry, realized that Lil Durk would actually have the capability to send out and put out a hit. This was a retaliation to another popular rapper in the drill genre of music, King Von. And so this was to enact revenge against the murder of King Von. What this goes to, though, Alex, is a larger conversation that we need to be having in America is how do we address gang culture? And then how do we address the violence that precipitates within particular urban communities? Every time we have a death or a murder such as this is when we need to be thinking about gun reform, gun legislation, and how much guns are on the streets, in particular within Chicago, which has a complicated dynamic with guns because of the bordering states that they have in terms of how the other states that surround Illinois have very loose gun restriction laws and the way that guns can flow into cities like Chicago. And so I think moments like this gives us an opportunity to address how are we going to tackle the growing issue of violence within our cities? How are we going to tackle gun violence and gun reform? And then how are we going to tackle the gang culture that exists in our major cities?
Well, and Shauna, one more here, because you mentioned conspiracy earlier. How might prosecutors be looking at this OTF group that Durk was a part of? I mean, are we going to see some repeats of what happened in the YS or what's happening in the YSL case?
Well, this one's going to be a little different because even when we look at the indictment, they already have text messages, which tends to lead me to the information that there may have been an informant because they got this information very quickly. Let's remember these arrests just happened. So they would have had to get these phone records. So if they have a direct source, we're going to see this move a lot more quickly. It cites text messages and phone calls where we can see the exact communications. So they have direct evidence already that's going to move this a lot more quickly than what we see in the YSL trial.
Gotcha. Okay. Mike Muse and Shauna Lloyd, thank you both.
I mean, all right, I got one more.
Lil Durk, the Chicago artist whose popularity has blown up over the past few years, while he is behind bars and headed for criminal court in California. Prosecutors say he orchestrated a plot to hire hitmen and take out a rap rival. As we're tracking the progress of this case, we're also taking a closer look at how we even got here and how an apparent feud turn deadly. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Well, Grammy Award-winning artist and reported multimillionaire Lil Durk, whose real name is Dirk Banks, is in a lot of trouble right now. The FBI says that he was part of a complicated murder-for-hire scheme that involved a shooting in the middle of the day at a Beverly Hills gas station in 2022. This actually resulted in the death of Savia Robinson, the cousin of Georgia rapper Quando Rondo, who prosecutors say was the actual intended target of this assassination, but he wasn't harmed in the shooting. According to prosecutors, Durk helped organize and pay for his alleged co-conspirators to travel from Chicago to Los Angeles in order to kill Rondo. Durk had reportedly put out a hit on Rondo, offering money to anyone who would take him out. Now, multiple people were indicted in California court, including Durk. Now, the named defendants in the indictment are Kevon London Grant, DeAndre Dontrell Wilson, Keith Jones, David Brian Lindsay, and Asa Houston. Now, Grant was reportedly a top associate in the OTF organization. This is the Family Rap Collective created by Durk many years ago, but authorities say this group functions more like a criminal organization with Durk at the very top. But to get to the heart of this alleged conspiracy, we need to take a step back and we need to understand what is this apparent long-running feud between Lil Durk and Quando Rondo, right? Why would Durk want to kill him? And to help me sort all of this out, because it is a little bit of a complex timeline, I want to bring in Sean Sataro, who is author of the book Dummy Boy, Tekashi 6ix9ine and the 9 Trey Gangsta Blood. Sean, thank you so much for coming on. Really appreciate it.
Hey, Jesse, thanks for having me. And yeah, you are right. This is complicated. I don't know if we'll be able to get totally to the bottom of it, but I will do my best. You know, there are some mysteries in this story.
Yeah, and first, before we even get into that, when you saw these charges, were you surprised?
I mean, yes, in that they were very serious. Obviously, murder for hire is a very serious charge. And, you know, Durk is a big star, and he seemed to be kind of moving away from, I guess, some of the sort of more sordid aspects of his image, right? He was making the move to television, right? He was on a Power spinoff. He had, I believe, the details are vague, but he had something to do with like his criminal record being wiped. He was getting, you know, proclamations from, you know, the mayors of cities. He seems, you know, he is now very sort of community oriented and all this stuff, and seems to be moving away from, you know, being involved in beefs and all this kind of thing. So I think as contrasted to his moves in, you know, recent months, the recent year or two, yes, I would say this, you know, this caught me by surprise. But obviously this beef, as we'll talk about, has a long history.
By the way, here on Sidebar, I talk a lot about the law. This is the Law and Crime Network. I talk a lot about the law, but I also talk about legal decisions, legal rulings. And I have a landmark one for you right now that has just changed things in a very big way. Why? Because you can now legally trade on who will win the 2024 election. Yes, legally. And that's because our sponsor of Sidebar, Kalshi, went to court and won legal approval for election trading for the first time in over 100 years. So not only can you essentially bet on the 2024 presidential election winner, but with Kalshi, you can bet on who will control the House and Senate, who's going to win the swing states. You think it's pretty timely? What's happening next week? And it's not just politics, by the way. You can bet on other future events too, like will Taylor Swift win top artist on Spotify this year? What's going to be the Rotten Tomatoes score for upcoming movies like Gladiator 2? I actually think it's going to do great. I think it's going to be above 85% personally, but there's so much more. You're going to be like, wow, I can trade on that? Yes, this is the only place to trade on events like this in all 50 states. And right now, you can sign up using our link, kalshi.com/sidebar, or scan the QR code on screen. And if you're one of the first 500 traders who deposit $100, Kalshi would give you a free $20 credit. That's kalshi.com/sidebar. And I want to give everybody a little bit of background here on the key players. So we're talking about 32-year-old Lil Durk. He was born and raised in Chicago. Got to start in music on social media platforms like MySpace and YouTube. He's considered to be one of the pioneers of what's called drill. It's a subgenre of hip hop. And he formed Only the Family in 2010 with his friend King Von joining on as well. Then you have 25-year-old Quando Rondo. Georgia rapper, first uploaded his music to SoundCloud, we believe in 2017. He joined up with NBA Youngboy's collective, Never Broke Again, in 2018. He's collaborated with him on multiple songs. Before we get into the actual feud between these two, I don't know if I'm doing it enough justice here, Sean, but talk to me about the influence of both rappers in the industry. How big were both of they? How big of an influence did they both have? Talk to us about that.
I would say, Durk is a major star. Like I said, he is moving into television. He's collaborated with, the biggest names in the industry, including Drake. He had I think is in the process of making a leap from being, someone rap fans know about to someone the general public knows about. I think that's true, not necessarily of Quando Rondo, but of NBA Youngboy, also who you mentioned, who is, by miles and miles, the most popular artist on YouTube. That's where, for whatever combination of reasons, and that's a whole other topic, a large part of his fan base lives. He is giantly popular. I would say, especially among younger listeners, and at this point has been around long enough to kind of be pretty influential. He and Quando Rondo are very close. Quando Rondo is signed to his label. And, Youngboy plays a large part in all of this, this whole sort of back and forth that forms the background to this case.
So we have these four men, right? We have Lil Durk, we have Quando Rondo, we have King Von, we have NBA Youngboy. And all four of them had crossed paths with each other over the years in the music world. But things really started to get heated when seemingly King Von appeared to diss some of NBA Youngboy's music during an Instagram live session. And that led to a whole flurry of back and forth on social media with insults flying between the groups. In 2020, King Von said on a live stream that there really wasn't a beef between him and Youngboy. He said, they be saying that a lot. It's like we got the same issues and women, and you know how the internet will try to make it, but it ain't nothing sincere, nothing that you should worry about. Then just days later, King Von would be dead because at around 2 a.m. on November 6, 2020, apparently Lil Durk's crew got into it with Quando Rondo's crew outside of a hookah lounge in Atlanta, Georgia. There ended up being a shootout. 6 people shot, 2 died, including King Von. And despite surveillance footage allegedly showing that a man named Timothy Leaks was the one who actually shot King Von, many believe Quando Rondo was really to blame for the confrontation. By the way, Leaks' murder charge actually ended up getting dismissed. But Sean, talk to me about the beginnings of this feud.
To a certain extent, the beginnings of this feud are sort of shrouded in mystery, right? You mentioned this Instagram live where Von is just in a car and listening to NBA Youngboy, and he, seemingly out of nowhere says, "Oh, NBA Youngboy, what's he doing? He lies in his music," right? I think says he has cap in his raps, right? Something to that effect, and that. What exactly caused that? Was that something he thought in the moment? Was it indicative of larger tensions that were bubbling behind the scenes? Honestly, I don't know. I don't think that many people outside of the real group of intimates of both sides knows. So maybe there was something before that, as far as I know, isn't public knowledge, but that was really sort of the first firing up of this back and forth that reached the public, right? And then, like you said, you had various back and forth, people, photographed with each other's girlfriends, doing songs with each other's girlfriends and baby mothers, and that ratcheted up the tension even more, and insults flying and all that kind of stuff. I'm happy to go into that in some more detail if you want, but
yeah,
to a certain extent. Sorry, I was going to say, to a certain extent, like I said, the beginnings are sort of shrouded in mystery a little bit.
Well, yeah, and I'm glad you mentioned that because, look, for Rondo's part, he's always maintained that he wasn't to blame for this Atlanta shooting, that he wasn't to blame for King Von's death. And he put out a song not long afterwards, after the shooting, where he talked about how it was all self-defense. Actually, in an interview in April of 2021, Rondo claimed that he was asleep in a car when all of this happened. He also claimed he didn't even know that King Von was there and he never had beef with him. He said, "I don't know where none of that came from. I never in life had words with them ever. I did not know that was him. I swear this is all. I did not know this was him until the next day. But according to the FBI, Durk had used coded language to put out a hit on Rondo, offering money to anyone who would kill his rival. And prosecutors say that is what led to the gas station shooting in Beverly Hills. So talk to me, Sean, about, more of this. You mentioned being with women, the songs. I think the songs back and forth, did that have anything to do with it as well?
Yeah, I mean, look, you can't know for certain, but definitely, there was a few months before the King Von shooting, Von posts a picture holding hands with a woman who was had a child with NBA YoungBoy. And, that was sort of taken by all parties to be an insult. Then YoungBoy, in retaliation, posts a photo of himself with his own son and captions it, "I'm going to make sure my son F your daughter since you're trolling." And many people thought that was directly aimed at Von. Quando at this point sort of jumps in. He defends NBA YoungBoy. There are, to recap this whole thing and all the shots back and forth, there are 13, 15-minute videos online that you can find, right, capturing every single back and forth. But, YoungBoy, a few days before Von is killed, does a song with Asian Doll, who Von had dated on and off. And then, a few months later, you have Von saying in interviews, "This is nothing too serious." And I think, you can kind of make of that what you will. But yeah, there were plenty of song and, plenty of sort of coded disses back and forth, or lyrics that I think fans interpret as being about each other, flying back and forth during this period as well.
Was there any overt threats? Anything like that?
I mean, I think it sort of depends on how you read the language. And in all of this stuff, I think there is a certain amount of sort of coded language, plausible deniability. I think Von's sister at some point gets dragged into this, but, lyrics about your sister could, in theory, be about anyone's sister, or a sort of generic, I'll get your relative, right? I'm not saying she was threatened. I forget the exact context of the lyric, but just for example, right? So I think, there are context clues that this is what was being talked about in these songs, certainly. But there's always that little bit of sort of plausible deniability. I think that's also true when you look at after, we'll talk about Quando's cousin being killed, but a few months after that, 5-6 months after that, Durk is in an interview with DJ Academics, and he's sort of talking about the beef, and he says very elliptically, he's referencing the fact that people have always told him, "Oh, you have to get revenge for Von, you have to get revenge for Von." And he says very elliptically, this is a few months after Quando Rondo's cousin is murdered, he says, "I don't hear comments like that anymore, for some reason." Those are his words, "for some reason," right? So there's always this like little bit of like, if stuff buried in how people talk during this beef.
It was interesting. I was talking to Bradford Cohen, who's a high-powered attorney, represents a lot of celebrities. And we were saying how, there might be multiple ways to look at this, because there's one text message that's really, really bad that might show Lil Durk's involvement in this. And I'm going to lay out what this murder for hire plot. But the way you can look at it is either A, he was a part of it, he was funding this, he knew what was going on, or he's like, "Listen, I don't know what you guys are up to. I don't know what you guys are doing. I'm staying out of it. Don't keep my name in this. I don't want to have any part of it." So obviously there's two ways to look at it. But I do want to talk about the shooting. So this was the culmination of this alleged murder for hire plot. And prosecutors allege that Lil Durk, he learned that Rondo was going to be in Los Angeles, so he helped pay for these alleged hitmen to fly down to San Diego, then drive to LA. Kevon Grant is the one who's accused of booking the hotels, getting the cars, buying the ski masks, finding weapons, including a gun that the government says had been modified into a full-on machine gun, which itself is a federal crime. And the indictment accused the defendants of following Quando Rondo's black Escalade around Los Angeles. And traffic camera, by the way, the photos, they show a white Infiniti following the Escalade until it pulls into a gas station, and the driver of the Infiniti parks behind the gas station in an alley. In the indictment, TB, by the way, refers to Taekwon Bowman, which is Quando Rondo's real name. SR is his cousin, who I mentioned before, Savai Robinson. And the indictment reads, on August 19th, 2022, at the Beverly gas station, defendants Jones and Lindsay and co-conspirator 2 used the firearms procured by defendant Grant, including the fully automatic firearm, to shoot at TB's car, striking and killing SR, who was standing next to TB's car while TB was inside. The images below show defendants Jones and Lindsay and co-conspirator 2 firing their guns at TB's black Escalade. And the filing includes surveillance photos of the suspects appearing to fire guns towards the gas pumps, again, in the middle of the day. And as I mentioned, Robinson was killed. Rondo, the alleged target of this hit, as I mentioned, wasn't hurt. Sean, that brazen attack, talk to us about when this happened, what the reaction was.
Yeah, I mean, wow. Yeah, I would say it was definitely very shocking, right? And, unfortunately, there have been any number of shootings of entertainers, of rappers in recent years. So unfortunately, there were precedents for this, right? You can talk about Young Dolph, other things like that have happened. So it was surprising. I think it was, very sad. Certainly, did people think about, well, who has Quando Rondo been, had public disagreements with? I think certainly that entered into some people's heads. It's tough. Andre G, who writes for Rolling Stone, had a fantastic article recently where he really decried this sort of fan pressure on Durk and on his crew to retaliate for Vaughn. Like, there were fans saying stuff like,
I read that.
You've got to slide for Vaughn, right? It really is very tough when fans treat this like a game, right? Where you have to get revenge and that, because of to uphold your reputation and all of this stuff. This is not to say Durk was involved in this, obviously, but just the fact that those comments even exist, I think, is indicative of, something that we really need to think about and examine.
I 100% agree with you. I read that article too. I didn't know what was going on, and to hear that, and I don't even want to say pressure, but to hear this kind of egging on and encouragement is really, really problematic because it's not a game. And I will say one of the other things that's problematic for Lil Durk is that on the day this indictment came down and his alleged co-conspirators were arrested, Durk, prosecutors say, was allegedly trying to flee the country, having reportedly booked multiple flights to places like the United Arab Emirates and Italy. And U.S. Marshals, they found him about an hour before he was supposed to take off. Again, I spoke with Bradford Cohen about this. A very interesting explanation for that. He said one of the things that you could see happen is sometimes people who think they're about to be indicted or about to be arrested, they will book flights to see if they get red flagged. It's a way to them. They're not actually intending to flee the country. They just want to see if they're going to get red flags so they know that an arrest might be incoming. Really interesting conversation about that. Now, at last check, Lil Durk was in the Broward County Jail. He's awaiting extradition to California to face these charges. So what does this mean for the apparent beef between Lil Durk and Quando Rondo? Well, Rondo actually released a new single from his album Here for a Reason just after the arrest. And the new single is called Life Goes On. And in an Instagram post, Rondo wrote, "We didn't get into this music industry to make it, just to stay caught up in this street S. We all have families and communities counting on us. It's time to leave all that behind. We've already lost so much, and it's heavy on my heart to forgive anyone I had issues with in the past. It's all love from me, praying for everyone." While he didn't specifically mention Lil Durk, it certainly seems or could be interpreted like he's addressing their feud. Sean, what'd you take away from that?
I was very glad to see that. I think it makes sense, right? And I hope that is his actual attitude and not for public consumption. I'm sure he feels all kinds of ways all of the time, but I hope that remains his sort of public stance about all of this. I know it surprised a lot of people. his response that it wasn't antagonistic and it wasn't even, let's let this play out, justice will be done, blah, 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 like you often hear from people in comparable situations, but that it was sort of an active call for peace and forgiveness and sort of hoping for the greater good. I was very pleasantly surprised to see that statement.
Yep, I think that's a really good way to look at it. Sean Sataro, thank you so much for coming on. Let everybody know where they can find you if they want to see more of your writings about the industry or other topics.
Sure, definitely. I have been covering the Diddy trial pretty extensively over at complex.com, writing a bunch of pieces for them. I just published one yesterday about his potential legal strategy, because there was a document kind of buried in the barrage of documents that, to me, laid out, I think, where his team is going. You can also find me on Twitter, or X, I guess now, at same old Sean, SHAWN.
I'm not even going to ask you what you think that is, because we could probably save that for another time, but also this is how I tease. So people now have to read your article and see what you think the legal strategy is. You see how I did that? So people now have to read your article to see what you think Diddy's strategy might be moving forward into the case. Sean Sataro, thanks so much for coming on. Appreciate it.
Thank you, Jesse. I appreciate it.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.
For some reason, it's not accepting any phone calls or any text messages. Y'all, I'm coming. Going to the settings. Okay. Oh, wait a minute. Hold on. I'm coming, y'all. Baby, I got a lot going on. Hold on. Okay, I'm going to yes, I am unprofessional cellular. Okay, I'm there. No. It says add. It says, hold on, it says, hold on a minute. Hey, y'all. Okay, hold on for a minute. Okay, y'all. So that's it for today. So let me get up off here because, of course, I got something to do. Hey, so make sure you do something good for yourself or someone else. Hey, make today a good day. Make tomorrow a better day. And hey, I'm out of here. So are you. Bye, y'all.